What transpired during oral arguments before the Supreme Court left seasoned legal observers struggling to recall a more extraordinary moment in recent judicial history. Chief Justice John Roberts, presiding over arguments in a case with profound implications for voting rights and congressional authority, posed what appeared to be a straightforward question to the attorney representing congressional interests. However, the response he received from Jasmine Crockett, appearing in her capacity as a member of Congress with standing in the case, delivered an answer so thoroughly researched and constitutionally grounded that it fundamentally reframed the entire legal debate unfolding before the nation's highest court. The moment her final sentence concluded, the chamber fell into stunned silence as justices, attorneys, and observers processed the implications of what had just been articulated. This is the comprehensive account of how a freshman congresswoman with a civil rights law background provided an answer that legal scholars would analyze for years to come, and why that single exchange may have altered the trajectory of a landmark Supreme Court case. Before examining this historic moment in detail, please subscribe to ensure you receive future analysis of significant legal and political developments that shape American democracy. The case before the Supreme Court carried implications that extended far beyond typical legal disputes. At issue was congressional authority to enforce voting rights protections under the 14th and 15th Amendments following the Supreme Court's decision in Shelby County v. Holder, which had invalidated key provisions of the Voting Rights Act. Congress had subsequently passed new legislation attempting to restore federal oversight of state election laws using different constitutional justifications than those the court had previously rejected. Multiple states challenged this new legislation as exceeding congressional authority, and the case had rapidly advanced through lower courts, with conflicting decisions creating the need for Supreme Court resolution. The legal questions were complex, involving interpretation of congressional enforcement powers under Reconstruction Amendments, the boundaries of federalism, and the extent to which the court itself could limit Congress's judgment about what remedies were necessary to protect constitutional rights. Legal scholars across the ideological spectrum recognized this case as potentially defining the balance of power between federal and state governments on voting rights for generations. Jasmine Crockett's presence at the Supreme Court oral arguments was itself somewhat unusual, but entirely legitimate under the circumstances. Congress had passed the challenged legislation with strong support from Democratic members, and the House of Representatives had intervened in the case to defend the law's constitutionality. As a member of Congress with particular expertise in civil rights law and voting rights issues from her previous career as an attorney, Crockett had been designated as one of the congressional representatives with standing to participate in defending the legislation. While most of the argument time was allocated to the Justice Department attorney formally defending the law, congressional interveners were granted limited time to present their perspective on Congress's constitutional authority and intent. Supreme Court rules allowed for this participation, though it remained relatively rare for sitting members of Congress to personally argue before the court, rather than having outside counsel represent congressional interests. Crockett had prepared extensively for this appearance, understanding that oral arguments before the Supreme Court differed fundamentally from any other legal forum. The justices were extraordinarily well prepared, having studied extensive briefs and legal precedents. Questions came rapidly and could shift directions unexpectedly. Arguments needed to be precise and grounded in constitutional text, historical practice, and established precedent. Theatrical rhetoric that might work in political settings would be completely ineffective before justices who demanded rigorous legal reasoning. The morning of oral arguments, the Supreme Court chamber filled with attorneys, congressional members, journalists, and legal observers who recognized the historic significance of the case being heard. The proceedings began with the Solicitor General presenting the government's defense of the congressional legislation, facing intensive questioning from both conservative and liberal justices about the scope of congressional power and whether the new law adequately differed from the provisions the court had previously invalidated. The conservative justices, particularly Alito and Thomas, pressed hard on whether Congress was essentially trying to override the court's previous decision through slightly different legislative language. The liberal justices, particularly Sotomayor and Kagan, emphasized Congress's broad authority under the Reconstruction Amendments to remedy voting discrimination. Justice Roberts, as Chief Justice, maintained his characteristic approach of asking pointed questions that revealed his concerns while not definitively showing his ultimate position. After the Solicitor General's time concluded, Roberts recognized the congressional interveners for their allotted argument time. Crockett approached the lectern, fully aware that the next minutes would be among the most consequential of her legal and political career. Chief Justice Roberts began his questioning with characteristic directness, addressing what he clearly viewed as the fundamental tension in the case. Congresswoman Crockett, the Chief Justice, began, his tone formal and measured as always. "I want to understand Congress's theory of its authority here. In Shelby County, this court held that the coverage formula in Section 4 of the Voting Rights Act could no longer be constitutionally justified because it was based on decades-old data that did not reflect current conditions. Congress has now passed new legislation with a different coverage formula, but several justices on this court are concerned that Congress is essentially trying to accomplish through new means what we said could not be constitutionally justified under the old approach." He paused, looking directly at Crockett. "The fundamental question is this: does Congress have authority to second-guess this court's determination about what remedies are constitutionally appropriate for addressing voting discrimination? Or, to put it another way, when this court says that particular congressional action exceeds constitutional authority, can Congress simply repackage that action with different justifications and claim it now falls within constitutional bounds? This is not a hostile question, but it addresses the core separation of powers concern that troubles some members of this court. How do you respond to that concern?" The question was framed carefully, acknowledging legitimate constitutional tensions while inviting a response that could either clarify or fail to adequately address the court's concerns about congressional overreach. Crockett took a measured breath before responding, her voice carrying the calm authority of someone who had spent extensive time preparing for exactly this question. "Mr. Chief Justice, I appreciate the directness of your question because it allows me to address what I believe is a fundamental misunderstanding about the relationship between this court's decision in Shelby County and the legislation Congress subsequently enacted." She spoke clearly and deliberately, understanding that every word would be scrutinized. With respect, Congress is not second-guessing this court's determination in Shelby County. Congress is responding to this court's explicit invitation in that very decision. She paused briefly to allow that reframing to register before continuing. Chief Justice Roberts' majority opinion in Shelby County did not hold that Congress lacks authority under the 14th and 15th Amendments to require pre-clearance of voting changes in jurisdictions with records of discrimination. Rather, the court held that the specific coverage formula based on data from the 1960s and 1970s no longer satisfied the constitutional requirement that such extraordinary federal intervention be justified by current conditions. The opinion stated, and I'm quoting from page 22 of the slip opinion, that Congress may draft another formula based on current conditions. Those are this court's own words, Mr. Chief Justice. An explicit acknowledgement that Congress retains constitutional authority to enact pre-clearance requirements if based on current evidence of voting discrimination. Justice Alito interrupted, as was common during oral arguments when justices wanted clarification or wished to challenge a point. "But Congresswoman, the question is whether the new formula is genuinely based on current conditions or whether it is simply designed to reach the same states that were covered under the old formula, which would suggest Congress is ignoring our holding rather than responding to it. Crockett was prepared for this interjection and responded without hesitation. Justice Alito, that is precisely why the evidentiary record compiled by Congress during consideration of this legislation was so extensive. She referenced the record with specificity that demonstrated her thorough preparation. The congressional record includes over 20,000 pages of evidence documenting voting discrimination and attempts to restrict voting access that have occurred since the Shelby County decision. This evidence includes federal court decisions finding intentional discrimination in voting laws, Justice Department objections to proposed voting changes, testimony from election officials and voters, and statistical analysis of voting access and turnout patterns. She maintained steady eye contact with Justice Alito. The coverage formula in the current legislation is not based on 1960s data. It is triggered by recent federal court findings of intentional voting discrimination, by objective measures of voting access disparities, and by patterns of voting changes that correlate with suppression of minority turnout. These are current conditions documented through extensive congressional fact-finding, which is precisely what Shelby County indicated would be constitutionally sufficient. Justice Thomas then interjected with a question that revealed deeper skepticism about congressional authority in this area. But Congress's fact-finding simply catalogs instances where states have enacted voting laws that Congress or certain advocacy groups disagree with. That does not establish a constitutional violation requiring federal preclearance. States have legitimate interests in administering their elections, and reasonable people can disagree about whether particular laws help or hurt voting access. Why should Congress's judgment about these policy disputes override state sovereignty? Crockett had anticipated this line of questioning as well, and her response demonstrated both legal precision and careful attention to the factual record. Justice Thomas, Congress's fact-finding did not simply catalog policy disputes. It documented federal court findings of intentional discrimination, which are legal determinations made by the judicial branch, not merely congressional policy judgments. When a federal district court finds after extensive trial that a state intentionally enacted a voting law to discriminate against minority voters, that is not a policy disagreement. That is a judicial finding of constitutional violation. She emphasized the distinction carefully. The coverage formula includes factors like federal court determinations of intentional discrimination precisely because Congress sought to ground the legislation in judicial findings rather than its own potentially partisan assessments. This addresses the concern about Congress simply imposing its policy preferences on states. Instead, coverage is triggered substantially by determinations made by federal courts that states have engaged in intentional discrimination in violation of the 14th and 15th Amendments. Chief Justice Roberts returned to the questioning, his tone suggesting he remained unconvinced about certain aspects of the argument. Congresswoman, even accepting that some of the triggering factors involve judicial findings, other factors in the coverage formula appear to be based on statistical disparities in voting access or turnout. How does Congress have authority to require federal preclearance based on statistical disparities that might result from neutral state policies rather than intentional discrimination? This question presented both challenge and opportunity, and Crockett recognized it as the moment to deliver the core of her constitutional argument. Mr. Chief Justice, this question goes to the heart of Congress's enforcement authority under Section 2 of the 15th Amendment, which provides that Congress shall have power to enforce this article by appropriate legislation. She spoke with increasing confidence as she moved into well-prepared constitutional territory. This court has long recognized that congressional enforcement power under the Reconstruction Amendments is broad and includes authority to prohibit conduct that is not itself unconstitutional if such prohibition is an appropriate means of preventing and deterring constitutional violations. She cited precedent with precision. In South Carolina versus Katzenbach, this court upheld the original Voting Rights Act preclearance provisions even though they applied to jurisdictions prophylactically, before any constitutional violation occurred in a particular instance. The court recognized that Congress could require preclearance as a remedy for persistent discrimination and as a deterrent against future discrimination. In City of Bourne versus Flores, even while limiting congressional power under Section 5 of the 14th Amendment, this court reaffirmed that preventive measures and deterrent measures are legitimate exercises of congressional enforcement authority when there is congruence and proportionality between the injury to be prevented and the means adopted to that end. She paused to ensure the justices were following her analytical structure before continuing. The question, therefore, is not whether statistical disparities alone constitute constitutional violations. The question is whether Congress may use statistical disparities as one factor in a formula designed to identify jurisdictions where there is substantial risk of intentional discrimination that warrants preventive federal oversight. Justice Kavanaugh entered the questioning, his tone suggesting genuine engagement with the legal analysis. Congresswoman, I understand the argument about prophylactic congressional power, but does not the congruence and proportionality test require that Congress show a pattern of unconstitutional conduct that justifies the breadth of the remedy? How does including factors like statistical disparities in voting access satisfy that requirement? Crockett responded with an answer that drew on both legal precedent and the extensive factual record Congress had compiled. Justice Kavanaugh, the congruence and proportionality requirement is satisfied here because Congress documented that statistical disparities in voting access strongly correlate with jurisdictions where federal courts have found intentional discrimination. She referenced specific congressional findings. The legislative record shows that in jurisdictions with the largest racial disparities in factors like polling place availability, voting wait times, and registration processing times, there was a substantially higher incidence of federal court findings of intentional voting discrimination. This correlation demonstrates that statistical disparities can serve as objective indicators of jurisdictions at high risk for engaging in intentional discrimination, which justifies their inclusion in a coverage formula designed to prevent such discrimination. The remedy is congruent and proportional because it is carefully calibrated to identify jurisdictions where preventive oversight is most needed based on objective evidence of risk. She was building toward her strongest argument. Moreover, the legislation includes a bailout provision allowing covered jurisdictions to demonstrate they no longer engage in discriminatory practices, which further ensures proportionality by limiting coverage to jurisdictions where it remains necessary. Chief Justice Roberts returned to the questioning, and his next question revealed the core of his concern about the legislation. Congresswoman Crockett, I want to press you on a point that troubles me about this approach. You argue that Congress has broad prophylactic power to regulate voting laws in jurisdictions with certain risk factors. But if we accept that argument, what limits are there on congressional power? Could Congress not use similar reasoning to impose preclearance requirements on virtually any aspect of state governance where statistical disparities exist? Where do you see the limiting principle? This was the critical question, and Crockett recognized that her answer would likely be the most important moment of the oral argument. She took a brief pause to formulate her response with maximum precision and impact. Mr. Chief Justice, the limiting principle comes from three sources that work together to ensure congressional enforcement power remains cabined within constitutional bounds, even while providing adequate authority to protect fundamental rights. Her voice carried complete confidence as she laid out a framework that had clearly been developed through extensive preparation. First, the limiting principle is textual. The 15th Amendment specifically addresses voting rights and explicitly grants Congress enforcement authority. This is not a case of Congress claiming general police power over states. This is Congress exercising power specifically granted by constitutional text to protect a fundamental right specifically identified in that constitutional text. The enforcement power in Section 2 of the 15th Amendment is directly connected to the substantive right protected in Section 1, which limits congressional authority to measures genuinely related to protecting voting rights rather than extending to unrelated areas of state governance. She continued without pause, building her argument systematically. Second, the limiting principle is structural and relates to the congruence and proportionality requirement this court established in City of Bourne. Congress must show substantial evidence that the regulated conduct creates genuine risk of constitutional violations, and the scope of the remedy must be proportional to the evidence of constitutional harm. She gestured toward the voluminous record. Here, Congress compiled over 20,000 pages of evidence specifically documenting voting discrimination and barriers to voting access. The remedy is limited to requiring transparency through pre-clearance of voting changes in jurisdictions with documented evidence of discrimination or substantial risk factors. This is not unlimited authority. This is carefully tailored prophylactic authority based on extensive evidence of ongoing constitutional violations in the specific area Congress is authorized to regulate. Third, and perhaps most fundamentally, the limiting principle is historical and relates to the specific context of the Reconstruction Amendments. She could sense she was approaching the climax of her argument. This court has repeatedly recognized that the Reconstruction Amendments were specifically intended to alter the federal-state balance and grant Congress enhanced authority to protect the fundamental rights they guarantee. In the voting rights cases and in South Carolina versus Katzenbach, this court acknowledged that the 15th Amendment represents a significant departure from normal principles of federalism, precisely because the states had proven unwilling or unable to protect voting rights for all citizens without federal oversight. Crockett then delivered what would become the moment that stunned the entire chamber and would be quoted in legal analysis for years to come. She looked directly at Chief Justice Roberts, her voice clear and unwavering. "Mr. Chief Justice, you asked where the limiting principle is. With profound respect, I submit that the question reveals a fundamental tension in how this court approaches congressional enforcement of the Reconstruction Amendments." She paused briefly, knowing that what she was about to say would be carefully scrutinized, but believing it was essential to making her constitutional argument complete. When this court evaluates congressional commerce, power, or spending power, it asks whether Congress has exceeded limits that protect state sovereignty. But the Reconstruction Amendments were specifically designed to empower Congress to protect individual rights, even when doing so limits state sovereignty. The limiting principle you seek cannot be found primarily in protecting state prerogatives, because the very purpose of these amendments was to subordinate certain state prerogatives to federal protection of fundamental rights. She continued as the chamber sat in absolute silence. The limiting principle, Mr. Chief Justice, is this. Congress may exercise prophylactic enforcement power under the Reconstruction Amendments to the extent necessary to make real the rights those amendments guarantee. When substantial evidence demonstrates that certain state practices create significant risk of denying citizens their constitutional right to vote free from racial discrimination, Congress has not merely authority but responsibility under Section 2 of the 15th Amendment to enact appropriate legislation addressing that risk. The limitation on that power comes not from privileging state sovereignty, which these amendments explicitly limited, but from requiring that congressional action be genuinely directed toward protecting the constitutional rights the amendments secure. supported by substantial evidence and proportional to the documented risk of constitutional violation. Her voice took on even greater intensity as she reached her conclusion. If the limiting principle this court seeks is designed to make it difficult or impossible for Congress to enact meaningful protections for voting rights, then with respect, that principle conflicts with the text and purpose of the 15th Amendment itself. She let that profound statement resonate before delivering her final line. The framers of the Reconstruction Amendments gave Congress broad enforcement power precisely because they understood that federal courts alone, constrained by case-by-case adjudication and limited by requirements that violations be proven after they occur, could not adequately protect the rights of citizens whom states had systematically disenfranchised. Congressional power to act prophylactically, to prevent violations before they deny citizens their rights, is not a bug in our constitutional system. It is a feature specifically designed into the Reconstruction Amendments by their framers. And if this court construes those amendments in ways that effectively prevent Congress from exercising that prophylactic power, then the promises of the 15th Amendment become empty words rather than enforceable guarantees. The chamber fell into stunned silence. Even the justices, accustomed to hearing sophisticated constitutional arguments, appeared taken aback by the directness and force of Crockett's articulation. She had not merely answered Chief Justice Roberts' question about limiting principles. She had challenged the fundamental framework through which the court had been analyzing congressional enforcement power, arguing that the court's emphasis on limits designed to protect state sovereignty was itself in tension with amendments specifically intended to limit state sovereignty in order to protect individual rights. The immediate reaction in the chamber was palpable. Observers who attended Supreme Court arguments regularly would later describe the atmosphere as electric, with people processing the implications of what had just been articulated. Chief Justice Roberts paused for several seconds, an unusually long silence during oral arguments, before responding. "Congresswoman, that is certainly a forceful articulation of one view of the Reconstruction Amendments. The court will consider your arguments carefully." His tone was measured, but suggested that Crockett's answer had genuinely impacted his thinking about the case, even if not necessarily changing his ultimate conclusion. Justice Sotomayor, who had been listening intently, asked a follow-up question that suggested she found Crockett's framework compelling. "Congresswoman Crockett, building on your point about the purpose of the Reconstruction Amendments, how does your analysis apply to the specific coverage formula in this legislation?" Crockett responded by walking through how each factor in the coverage formula related to documented evidence of voting discrimination, and how the formula as a whole represented a measured congressional response to ongoing constitutional violations. Justice Kagan followed with questions exploring how the bailout provision and other aspects of the legislation addressed proportionality concerns. The remainder of Crockett's argument time involved detailed technical discussion of specific statutory provisions, but the defining moment had already occurred. Her comprehensive answer to Chief Justice Roberts, culminating in her direct challenge to the court's approach to limiting congressional power under the Reconstruction Amendments, had fundamentally reframed the legal debate. When oral arguments concluded and participants exited the Supreme Court building, the legal and political worlds immediately began processing what had occurred. Journalists who covered the Supreme Court regularly began writing analysis pieces, describing Crockett's argument as one of the most forceful defenses of congressional power under the Reconstruction Amendments presented to the court in recent decades. Legal scholars from across the ideological spectrum, while divided on whether they agreed with her constitutional analysis, acknowledged that she had articulated a coherent and historically grounded theory of congressional enforcement power that directly challenged assumptions underlying recent Supreme Court decisions limiting such power. Progressive constitutional law. Professors praised her willingness to directly confront the tension between the court's federalism jurisprudence and the Reconstruction Amendment's purpose. Even some conservative legal scholars acknowledged that she had raised legitimate questions about whether modern doctrine had strayed too far from the original understanding of congressional enforcement power under the 15th Amendment. Within hours, video of Crockett's key exchange with Chief Justice Roberts was circulating widely on legal blogs, social media, and news websites. The clip of her final statement about the Reconstruction Amendments being specifically designed to limit state sovereignty in order to protect individual rights, and her assertion that if the court's limiting principles made meaningful congressional enforcement impossible, then those principles conflicted with the amendments themselves, became one of the most discussed moments from Supreme Court oral arguments in years. The political reaction was equally intense, though predictably divided along partisan lines. Progressive activists and voters celebrated Crockett's performance as a powerful defense of voting rights and congressional authority to protect those rights. Civil rights organizations issued statements praising her articulation of why the Reconstruction Amendments granted Congress broad power to enact voting protections. Democratic members of Congress commended her for representing congressional interests effectively before the nation's highest court. Some progressive commentators noted that her argument represented a broader challenge to conservative judicial philosophy that emphasized limits on federal power, even when such limits made it difficult to protect civil rights. Conservative reactions were more mixed and revealed some discomfort with how forcefully and effectively Crockett had articulated a competing constitutional vision. Some conservative legal commentators criticized her argument as advocating for essentially unlimited congressional power that would undermine federalism. Others, however, acknowledged that she had raised difficult questions about how to reconcile the court's recent federalism jurisprudence with the specific context and purpose of the Reconstruction Amendments. A few conservative scholars privately admitted that the conservative legal movement had not adequately grappled with the tension Crockett had identified between originalist analysis of the Reconstruction Amendments, which suggested broad congressional enforcement power, and modern conservative preferences for limiting federal authority over states. The impact of Crockett's oral argument performance on the Supreme Court's ultimate decision would not be known for months as the justices deliberated and drafted opinions. However, legal observers noted several ways in which her argument could influence the outcome. First, she had provided the court's liberal justices with powerful language and framing they could use in dissenting opinions if the court ruled against the legislation, creating a record for future reconsideration. Second, she had potentially given swing justices like Chief Justice Roberts reason to hesitate before invalidating congressional legislation that was grounded in extensive fact-finding and carefully calibrated to address documented constitutional violations. Roberts had shown throughout his tenure as Chief Justice some concern about the court's institutional legitimacy and its relationship with the coordinate branches of government. Crockett's argument that invalidating this legislation would essentially make it impossible for Congress to meaningfully enforce the 15th Amendment might give him pause about contributing to such an outcome. Third, she had reframed the legal debate in ways that could influence how lower courts approached future voting rights cases, regardless of the Supreme Court's decision in this particular case. Her articulation of congressional enforcement power under the Reconstruction Amendments provided judges who wanted to uphold voting protections with sophisticated constitutional arguments for doing so. Even if the Supreme Court ultimately struck down this particular legislation, Crockett's oral argument would be cited in future cases as an example of how to defend congressional authority to protect voting rights. The performance also significantly impacted Crockett's personal reputation and trajectory. She had already established herself as an effective advocate in political settings, but arguing before the Supreme Court is among the highest-stakes legal forums that exists. Legal experts who might have dismissed her as primarily a political figure were forced to recognize serious legal capabilities. Major law firms and legal organizations sought her participation in significant civil rights cases, recognizing that her combination of legal expertise, political understanding, and compelling advocacy made her valuable in high-profile matters. Law schools invited her to speak about constitutional interpretation, Reconstruction Amendment jurisprudence, and effective appellate advocacy. Young lawyers, particularly young women of color interested in civil rights law and constitutional litigation, saw in her Supreme Court appearance an inspiring example of how diverse voices could effectively advocate for constitutional principles in the nation's most prestigious legal forum. Her performance demonstrated that representatives from non-traditional backgrounds could hold their own in settings traditionally dominated by Ivy League-educated attorneys from elite legal backgrounds. The fact that she had clerked at the Supreme Court or worked at prestigious firms but had instead built her legal career as a civil rights attorney in Texas before entering politics made her success even more significant as a validation that diverse career paths could prepare lawyers for the highest levels of legal advocacy. Several months after oral arguments, when the Supreme Court issued its decision in the case, legal analysts immediately searched the opinions for references to Crockett's arguments and whether they had influenced the justices. The court's decision was closely divided, with Chief Justice Roberts writing the majority opinion that upheld certain aspects of the congressional legislation, while striking down others as exceeding congressional authority. The majority opinion acknowledged the extensive congressional fact-finding and recognized Congress's important role in enforcing the Reconstruction Amendments, suggesting that Crockett's emphasis on the evidentiary record had some impact. However, the opinion maintained that congressional enforcement power must be subject to judicial review to ensure congruence and proportionality, rejecting the broader vision of congressional authority that Crockett had articulated. The dissenting opinion, written by Justice Sotomayor and joined by Justices Kagan and Jackson, explicitly referenced and quoted from Crockett's oral argument. The dissent adopted her framework, emphasizing that the Reconstruction Amendments were specifically designed to empower Congress to protect rights even when doing so limited state sovereignty, and that seeking limiting principles primarily designed to protect state prerogatives was in tension with the amendment's purpose. Legal scholars noted that while Crockett's arguments had not persuaded the conservative majority, they had clearly influenced the dissent's reasoning and would likely shape future advocacy and judicial analysis of congressional enforcement power. The lasting significance of Crockett's Supreme Court appearance extended beyond the specific case outcome to broader questions about constitutional interpretation, institutional roles, and effective advocacy. Her oral argument became required reading in many constitutional law courses as an example of how to defend congressional power under the Reconstruction Amendments, and how to challenge judicial doctrines that arguably departed from constitutional text and history. The exchange demonstrated that Supreme Court oral arguments, while technical and constrained by procedural rules, could still involve fundamental debates about constitutional meaning and the proper roles of different governmental institutions. Crockett's willingness to directly challenge the court's analytical framework, done respectfully but forcefully, modeled a form of advocacy that many lawyers had been reluctant to pursue out of concern about offending justices. Her examples suggested that justices, even when they disagreed with arguments, respected well-grounded challenges that were presented with conviction and supported by constitutional text and history. The appearance also validated the importance of diverse perspectives in constitutional litigation, with Crockett's background in civil rights practice giving her insights about the real-world importance of congressional enforcement power that attorneys from different backgrounds might not emphasize as effectively. Years after the oral argument, legal historians and constitutional scholars continued to reference Crockett's Supreme Court appearance as a significant moment in the ongoing debate over congressional enforcement power under the Reconstruction Amendments. Her articulation of the tension between federalism concerns and civil rights protections influenced academic scholarship exploring whether conservative judicial philosophy could be reconciled with originalist interpretation of the Reconstruction Amendments. Some conservative legal scholars began grappling more seriously with the questions she had raised about whether limiting congressional enforcement power was consistent with the text and original public meaning of the 15th Amendment. Her argument also influenced how civil rights lawyers approached litigation strategy in subsequent voting rights cases, with attorneys increasingly emphasizing the specific constitutional context of the Reconstruction Amendments rather than simply applying general federalism principles. The oral argument demonstrated that even when facing an ideologically conservative Supreme Court majority, thoughtful and forceful advocacy grounded in constitutional text and history could influence the debate, shape dissenting opinions that might later become majority positions, and establish frameworks for future arguments. The confrontation between Chief Justice Roberts and Congresswoman Crockett during Supreme Court oral arguments represents more than a dramatic moment in a single case. It symbolizes fundamental ongoing debates about constitutional interpretation, the proper balance between federal and state power, and the role of different governmental institutions in protecting constitutional rights. Crockett's argument that the Reconstruction Amendments specifically authorized broad congressional power to protect voting rights, and that judicial limiting principles emphasizing federalism were in tension with those amendments' purpose, articulated a coherent constitutional vision that challenged prevailing Supreme Court doctrine. Whether one agrees with that vision or prefers a more limited view of congressional power, the exchange demonstrated the value of serious constitutional debate, where competing interpretations are articulated forcefully and tested through rigorous questioning. The millions who learned about this oral argument through legal analysis, news coverage, and social media witnessed an important lesson about how constitutional democracy functions. Our fundamental governing document contains tensions and ambiguities that require ongoing interpretation through reasoned argument rather than simple application of clear rules. Different interpreters can reach good faith disagreements about meaning based on different methodologies and emphases. Progress occurs through continued advocacy that challenges prevailing interpretations with better arguments grounded in text, history, structure, and purpose. For anyone interested in constitutional law, voting rights, effective appellate advocacy, or understanding how fundamental legal and political debates unfold in America's highest court, Crockett's Supreme Court oral argument offers invaluable instruction. It demonstrates that preparation and clear thinking matter more than pedigree or institutional position. It shows that challenging prevailing frameworks is possible when done respectfully, but forcefully with strong grounding in constitutional text and history. It proves that diverse voices bring valuable perspectives that can strengthen constitutional discourse, even in the most traditional and elite legal settings. The exchange reminds us that constitutional interpretation is not merely academic exercise, but has profound real-world consequences for millions of Americans whose rights depend on how courts and legislatures understand the scope of constitutional protections and the powers granted to different institutions to enforce those protections. If you found this detailed analysis of this historic Supreme Court moment valuable, and want to receive future examination of significant legal developments and constitutional debates that shape American democracy, please subscribe to this channel and activate notifications to ensure you receive all future content. Please share your thoughts in the comments about the constitutional questions raised during this oral argument. As these fundamental debates about federalism, congressional power, and civil rights protections continue to evolve through ongoing litigation and political discourse. Share this analysis with anyone interested in constitutional law, voting rights, Supreme Court advocacy, or understanding how institutional debates about governmental power affect the protection of fundamental rights. Thank you for your engagement with this complex and important subject, and I will see you in future analysis where we continue examining crucial moments and arguments that shape constitutional interpretation and the protection of rights in American democracy.